Hi, I am Pedro Gonzaga from the OECD Competition Division, and today we have here with us Avantika Chowdhury from Oxera, who just participated as an expert speaker in our roundtable on competition and e-commerce. One of the problems centrally around e-commerce is the centrality of data, which may have both benefits and concerns for competition policy. So I would ask you, what do you think are the key characteristics of data that could eventually raise concerns for competition?
Sure. So the first thing about data that is gathered by platforms, the first characteristics that is relevant is the cost of acquiring that data for a competing platform. So if you think about data on my browsing history or my social graph, as in what I'm discussing with my friends on Facebook, that is something difficult for a competing social network platform to acquire, and that cost of acquiring data is important because that acts as a barrier to entry. The second characteristic that is actually important is the depreciation rate of the data, i.e. how long is the data being collected from me, how long is it relevant for advertisers, for other platforms, for like suppliers. So that is quite important.
So, and when you mentioned the depreciation rate of data as an important factor, would you say that high depreciation creates more competition concerns or less concerns for competition?
I don't think the answer is as clear-cut, unfortunately or fortunately. We can't really say that high depreciation is more problematic, and it really depends on the context. So to give you an example, if I am a consumer who wants to book a hotel in Paris and I Google in my search box Paris hotels, then that data has a high depreciation rate. Why? Because 1 week later, it matters less whether I Googled Paris today or not, or 1 month later. But it is very relevant for hotels or other advertisers who immediately want to get that data and then advertise their hotels on the sidebar. And so in this case, so in the hotels market, it is relevant that the high depreciation actually causes more of a problem, or can cause more of a problem, because it means that it is very relevant to hotels and to other platforms, but they are not getting something that is very important to them. In contrast, if I am trying to buy a watch and I type in Google watch brands, then in this context, if there are some concerns about competition in commodities or in merchandise, let's say in watches, as a stylized example, it is really not so important that another platform, Bing or Yahoo, is not getting this data that I've typed watch or Rolex watch, because chances are that this is not something that I've just thought about buying today, but this is something that is more deliberate, and therefore I've thought about it a lot. So whether a competing platform shows me an ad for a watch or not, it matters less.
So at the end of the day, data can have different depreciation rates. It's important to analyze data, taking that into consideration, but whether that poses a competition concern or not should be evaluated on a case-by-case basis.
Yeah, depending on whether the data, the urgency of the data, depending on the urgency of that data requirement.
And still on this data topic, which has been a very hot topic, even in previous roundtables here at OECD, this is often related to concerns about privacy, about consumer protection. Yeah. So I would ask you, do you believe that competition policy is always the best tool or the best law to address these concerns about abuse of dominance or abuse in the collection and processing of consumer data?
No. I must admit that I don't think competition policy is the best tool. to address concerns about collection of consumer data, precisely because I think there are other laws, there are privacy laws. You can try to use consumer protection powers as well to tackle it, but I don't think competition policy, in particular, Article 101, 102 are the right tools, because as we know, it's very difficult to establish the conditions needed to apply 101, 102. And here I want to contrast the approach of the German Competition Authority and the Italian Competition Authority. Both of them are looking at Facebook's policies, privacy policies and data protection policies.
But using different tools.
Using different tools, exactly. The German Competition Authority are trying to use the abuse of dominance as a part of their investigations, while the Italian Competition Authority has taken the view that they will use their consumer protection powers to investigate the privacy policies regarding whether it was transparent, whether consumers were aware, whether they agreed, etc. So, and my view is Italian way is the better way.
Well, I think the Facebook case is in fact a very good illustration. This has been a case subject to a lot of discussion, and where if indeed you have two completely different approaches by different competition authorities.
Absolutely.
So, thank you so much for coming here today, for participating in our roundtable.
Sure. Thank you.